Good morning, everyone. This is Gaurav Chaudhary from SHM, and we welcome all the attendees at the Intellectual Property Talent Search Examinations 2021 interactive session. And we also welcome Dr. Sheetal Chopra, IPR chairperson from SHM. And today she will be taking care of the introductory part of the IPTSE format and the concept. And she will also give few points and suggestions on the career aspects on the IPR and the future, how it's going to be useful to everyone. And we are also welcoming all the faculties and the students to please share your queries and doubts over mail or in the chat box so that we can answer it. And now over to Dr. Sheetal to please start the session, ma'am.
Yeah. Thank you so much, Gaurav, and I'm super excited to be part of this interactive platform. Just a little bit of administrative couple of things, because whenever someone is presenting, I think it is very good that a presenter gets a lot of questions or maybe some comments on the chat box, because then it can really feel like that you're not talking to yourself, but you're talking to, live audience over there. But as Gaurav said, this is one of our interactive interactions that we are having with all of you. I've heard that there are a lot of students, community, and especially the kind of colleges who are able to make themselves available for today's session. They are primarily from the engineering side or from the technology side. And therefore, I have tried to make a presentation in a form that really addresses or really connects you well. I thought of making a very brief presentation. I think it will go for around 30 minutes or so. And the next 30 minutes, we are going to keep it open for the interaction. Once again, before we start, I really encourage you to, put more questions on chat. I have already kept the chat window open, so that I know that, everyone is attentive and you are able to get what we are trying to bring forth to you. So yes, as Gaurav said, this is about the Intellectual Property Talent Search Examination. During your very young time, during school examinations and all, you would have heard about Science Olympiad or Mathematics Olympiad or English Olympiad and several of such Olympiads. We thought that it is extremely important that we introduce subject of intellectual property as well and create a forum which offers all the students an IPR Olympiad. And we have deliberately kept the name or we have launched it under the brand name of Intellectual Property Talent Search Examination, because we really want to identify the talent in India. As to there could be some young minds who've got very strong innovative mindset or they've got very creative mindset. There may be some inclination towards developing something for the country which is good for the local use, not only for the local use but also for the global use. And therefore identifying that talent became a very important component of this initiative. Before I really take you through what IPTSE in abbreviation, which we also call as, refer as IP Olympiad, just for the sake of ease, I think it will be very important that we go through, first of all, what intellectual property is all about. And then we also, interact on what are the different forms or new career choices that you can build with this subject matter. I hope you are all able to see my slides. Just a bit of disclaimer that this presentation should not be connected to any thought process of my employer. It is primarily for the academic purposes, and anything that I state today in this presentation should not be taken as a legal advice. So this was a disclaimer that we usually give, because it's one of the important components of IPR that when you are making presentation for academic purpose, it is used only for that purpose and not for any other legal point of view. So I think IP is a word which is non-escapable. Whether you start a day right from the beginning till the night, you are all, associated, and you are completely in the mix of intellectual property around you. Starting from your toothbrush to your breakfast, where you use microwave oven, or you use several other devices. You go to your university or you go to your offices. You use all the vehicles. Everything forms a part and parcel of intellectual property. In fact, the kind of device that you use, whether you are attending this lecture by way of mobile phone or you are using laptop, every such product has an IP component today. Since we already are in the midst of intellectual property, you look around here, you look at air conditioning, you look at the way the room is built up, the kind of content that is there, that you are even creating while you are sitting and making a presentation. Everything is intellectual property. And therefore, it becomes extremely important that you become aware of the subject matter, not at all only with the intention in mind that maybe you want to build a career in this theme or in this sector or in this area, but generally as a parent, as a child, as a student, as a literate citizen of the country, you should anyway be aware of intellectual property. Because it's not only that we are using it all the time, but also we end up creating sometimes IP, even in our home. And I'm going to take to you through some examples as we move or progress in the subsequent slides. Okay, so one question that I wanted to ask you, are you aware of this? Is anybody aware of this logo called Foodie Bay? Anyone? If you can just type it in the chat window, I'll just have a sip of my coffee then. Anybody, if you have ever heard of this logo or this trademark anywhere, maybe when you're ordering your food online? No. Yes, absolutely. Because there was an IP dispute. There was somebody who wanted to launch for the first time on the e-commerce website the opportunity to provide to the consumer where they can order food online, right? Consider this few years ago when this system was just in vogue and it was just coming up, and Foodie Bay was the trademark under which they wanted to launch it. It could not be launched because eBay did not allow it. eBay said that this looks very similar to my own trademark or the logo, and therefore the company had to change the name. It changed the name to this, Zomato. So Zomato, if it would have come erstwhile ago and there would have been no IP dispute, you would have actually you would have actually understood Zomato as actually Foodie Bay and not Zomato. But because there was IP involved, they had to change the name, and therefore we now know, everyone know about Zomato, where we order food online and everything. I think through this slide, what the take-home message is that anything that you do, any product that you may launch in the coming future, or you want to launch some services, you need to be very careful under which name do you launch. Because even before you launch it under any name, there could be some disputes right in the beginning when you file for an application for the grant of that trademark. And even more worse, if you have not checked whether it actually belongs to someone or not, then you may end up in the litigation. So therefore, this is a very simple layman's example that I found, and I thought we all will be able to connect with this better. So intellectual property is nothing but it is actually the creation of mind. There is some typo that I can just see here. One can, it should be can, not can. These are all intangible things. Whatever even I'm thinking in my mind right now, you may be thinking something. It could actually be part of the intellectual property because you may be thinking and trying to bring out something for the market which may not have been initially created. So IP is all about your intangible assets. It is similar in rights as you may have when it comes to physical property, like you have a home or you have a car, you can rent your car, you can sell it out, you can give it on lease, you can give your home on lease, you can mortgage it. Everything that you can do with the physical property, you can actually do with the intellectual property. So if we were always imagining that it is only the assets, the physical assets that could have got you money, I would say no, because today the companies are actually shifting away from having tangible assets to intangible assets. In fact, in COVID time, like we are in today, companies don't have brick and mortar type structure. There are no offices anymore. Everyone is working from home. And therefore, their physical assets are actually coming down and intellectual assets are actually going up. And this is where the role of intellectual property becomes very important because I can see some noise. Is there somebody who wants to say something? Gaurav?
No, not yet.
Okay. Do please let me know if I'm going very fast or you want me to have a different rate of the way I'm speaking. So please keep sending in the chat section.
Sure.
Doing. Yeah.
That's perfectly fine.
All right. Thank you. So intellectual property is all about an intangible asset. Most of the times, since you are from the most of you are from the engineering background, I'm sure that, you all know that in the market, jobs may be at dirt. In fact, Government of India has launched a very important initiative of Startup India and Stand Up India. Most of you, even faculties, those who are involved in R&D, even if not in R&D, but in any other service line or in a product line, you may wish to initiate your own company. And that is where having a good IPR portfolio definitely helps. And we are going to see how. In fact, as you can see from the title here on this page, rags to riches and riches to rags. Intellectual property has that kind of a capacity. If it is used in a best way, if you know the nuances of intellectual property, if you are IP literate, if you have even a reasonable amount of understanding of IP, it can actually make you take you from rags to riches. And any ignorance about intellectual property or any sort of misuse of intellectual property, misappropriation, so to speak, can actually bring you from riches to rags. And let's see some examples. You see Sam Pitroda here. You see Chetan Bhagat. We all know about all these celebrities who've been listed on this slide, whether it's Shiv Khera, the well-known author, or Mr. R.A. Marshelkar, the erstwhile DG of CSIR, or Javed Akhtar, a famous celebrity from the Bollywood, absolutely fantastic writer and a lyricist. All of them, what is one thing common in all of them is the use of intellectual property. The kind of content that they all have created, whether Sam Pitroda in the telecom sector or Ritu Kumar in fashion designing sector, or let's say Chetan Bhagat in the literary sector, where he's been writing a lot of books, or Javed Akhtar with regard to the famous and very, soothing music that he creates. This is all intellectual property. Now you may ask, how did they become rich? What did they do? Because they were able to use intellectual property in a way that they were able to stop others from misappropriating their IP. And they've been able to utilize their intellectual property in order to monetize. For example, if we just take an example of Chetan Bhagat, I don't think we all knew him as much as well as we know him today, at least until before the Three Idiot movie that came out. He had written a book, a novel, where director went to Chetan Bhagat and he said, I loved your novel, the script is good. Why don't you share it with us and we will create a movie. And for that, we are going to pay you a good attribution and acknowledgement in the movie itself. Anyway, there could have been more terms and conditions with regard to the royalty payment and everything. But it was found by Chetan Bhagat that when this movie was launched, Three Idiot, and you see those acknowledgement sections, the name of Chetan Bhagat was at the end, or it was not as conspicuous. that all of us as consumers would have got to know. So he got very worried and he said that this is my IP and this is what I created. You must have given me due acknowledgement and accreditation, which has not happened. And thereafter, everything came in the press. And from there on, we started knowing him. People, in fact, director also said to an extent that it has nothing to do. The movie that we have created is quite different from the novel that you have written. But then dispute went to the court and it was very clearly mentioned. In fact, the verdict came out that it is actually the script of Chetan Bhagat, which has been now converted into a movie form. And thereafter, we all started to know him. So we all started to know Chetan Bhagat because of his intellectual property. Similarly, for Sam Petroda or Ritu Kumar, we all know her for the great designs of the apparels that she makes. And there have been a lot of disputes where people have been copying her work, and she was really very very strong in terms of protecting her intellectual property. Even Javed Akhtar, this person, he was the leader in actually bringing a lot of changes in the Indian Copyright Act, and made sure that every author, every content creator, every writer, gets fair amount of revenue and royalty upon the sale or use of the intellectual property. So this is where, these are the examples of, taking people from rags to riches. And there are also, few more examples where it's not up to the life of the creator or the inventor that you can only monetize your IP, even after the death. And there are umpteenth examples that we can actually talk about, we can research about, where even after the death of people, they were able to, or the creators or inventors, they were able to earn in billions and millions. So it's not only limited to the person who creates, but also to the legal heirs that it goes down to upon the death, until the intellectual property term is alive under the different statute books where intellectual property is granted. There is also a very good example that, of course, I know this person very well, Vishen. He has been a very, very senior person in one of these multinational companies. He left his job and he actually followed his passion. He followed the passion of creating something for the country. And he came up with his invention. He started his own startup. He got his IP granted in the under the Indian patent system, also across the globe. And just because he was able to identify the intellectual property and also protect it in a timely fashion, he was able to receive a good fund from the angel investors. I think he is one icon that everyone should learn from. After this session, you can go check about this vision, what it is all about. And maybe, if at a later stage we are able to get connected with him, we might as well have him for one of the lectures where he can actually convey you his journey from actually, starting a very small startup to identifying his intellectual property, to protecting it, getting a lot of memorandum of understanding, signed up, and then coming up with a startup that is now well known and has been able to receive a lot of funds. Okay, so we have seen the examples of how people have actually transformed themselves from rags to riches by the use of intellectual property. There are also examples where people from riches to rags they have become, just because they did not know what to do. There has been one very young author who was all set to make a lot of fortune. He wrote a book. It could have been the bestseller, but he had to withdraw the entire set of copies from the market because, two of the other authors, Meg Cabot and Salman Rushdie, they litigated and they said that, some of the pages in your book are actually our own work. That has been a lifted work. And therefore, the awareness of intellectual property becomes absolutely critical. It's not only, as I'm just re-emphasizing, it's not only that you want to make a career in IP all the time, but even if you're a doctor or you want to become an engineer or you want to become a fashion designer or any other sector that you want to build your career in, intellectual property as a subject should definitely be known to you, so that you know if you have created something or you are using someone's IP, you don't land up into some trouble. Similarly, since we are all going digital today, a lot of content that you all create on WhatsApp, on social media websites, on so many other platforms, it actually belongs to you. You can actually use it in some way. So therefore, understanding of IP becomes absolutely critical. Like I shared with you one example of Vision, a startup, there have been several other examples. This slide is a bit dated, not as dated I would say, but I still kept this slide because at least it's good to get the message home. Over a period of time, if you look at the rounds of discussion with venture capitalists, the different startups or different people who are having innovative bent, they talk to them. Those who had a good IP portfolio were able to get a lot more funding as against to zero funding from venture capitalists, if they did not have a good IP portfolio. So it is very important that you know that you should be knowing about this subject. Let me meanwhile also look into the chat box so that if there is any connected question, I can take it up right now. So there is a question by Animesh who says that if a designer or original maker has not registered his work as an intellectual property with the competent authority, can he still file a case? Yeah. So actually it's a very good question because, people who are having a lot of creative bent of mind, they don't really bother about running to the offices, going to the law firms, getting into the issue of protecting their IP. But protecting IP may not be must when it comes to literary work in the copyright area, but when it comes to a technology, you must have an intellectual property in the form of patents. If you don't have a patent, you cannot sue anybody. But when it comes to a trademark, or it comes to a design, in fact, design rights are again important. If you are not protected under design, you cannot stop an infringer from using your intellectual property. But when it comes to a book, a literary program, or maybe script that you may have written, from that creative side that falls in the category of copyright, the registration of IP may not be important. But if you want to go to the court and sue someone, then even judge will ask you that whether you are a true owner of IP or not. So a registration certificate then becomes very, very important. And then, so I think protection of IP is always good to have and must when it comes to design and the patent side of it. So there are some other questions that are being asked. For example, Sudhakar is asking, some words which are common can have IPR. I think this is a very generic question. I'm not able to comprehend it well, Sudhakar. If you can convey with some example, are you talking about some logo, or you are talking about the trademark, or what are you talking about? Some words which are common can have an IPR. I don't really understand this one unless I have a little bit more information from you. But I can presume that you're talking about some word in the sense of protecting it under a copyright or a trademark. Then yes, if there is something so common, if it is not distinctive, then having a trademark is very difficult, unless it has become a well-known mark. For example, what example can I give you? Make My Trip, okay? So Make My Trip, these are very common names. These are very common words. We all know it's a part of our dictionary, English dictionary, Oxford dictionary. Everyone knows about it. But still, they were able to receive a trademark because even before they got a trademark granted, Make My Trip was already being used by most of the consumers. It had become well known. It has received a distinctive flavor. So yes, there are yes and no, but depends on the case in hand or what particular issue that we have. There is also a question by Sheetal Chopra who is asking how is IP managed by social media companies, for example, Twitter and Facebook. I think Facebook, even if it is a social media platform, but it is actually a whiteboard where the consumers or the customers or subscribers who are part of Facebook, they are the ones who are creating the content. So the one who posts the content on Facebook, who creates the content, becomes the IP owner and not really the Facebook. Unless Facebook itself has created something, some presentation, some other important creative content, then it belongs to them. But anything that is posted on Twitter or any other social networking sites, I won't say it as social media company, I'll say it is a social networking sites where people network with each other. You create your own content, so you become the intellectual property owner for it. Well, I'm so happy to see that there are a lot of questions being asked. Even there is another question by Gaurav who asks, after patenting, it is necessary to keep paying every year. Yes, it is until the time 20 years are over. If you are keeping your patent live for that term for 20 years, you have to keep paying annually, but the annual payment is very less for startups. For individuals, I think it is 75% less than if it would have been filed by any other legal entity. Rakesh also asked a question, is it necessary to go for patent in each country or Indian patent will protect my IPR? Well, patent in each country, there is nothing called as global patent. Gaurav, can someone go on the mute because I'm hearing a little bit of sound in the background and that's quite distracting.
Okay, I'm sorry. I'll take care of it. Right.
All right. So yes, when it comes to patent is a territorial right. It is only, your invention is protected only in the country in which you protect your patent, not in any other part of the country. So if you want to launch your product, let's say in America, you want to US, you want to launch your product in, let's say, Europe or Japan, China, you have to pick and choose the countries in which you want to protect your IPR, and then only in that country it will be protected. But just having an India patent will not secure you rights in any other part of the world. So Sudhakar, yes, I understood it correctly. I have given you the response to your question, which is about the logo, where we use the word, one case in point, make my trip. I hope that was clear to you. And we also have question from Rajat Verma. Do we need to register IPR somewhere? Yes, you have to register at least in the country where you create your IP, you develop. In India, also in the countries where it's your important market. So you have to identify if India is a market, go ahead, protect it here. But if India is not a market, you want to protect somewhere else, go protect it there. But then wherever you don't have an IP protection in the form of patent for your invention, in those countries, you would not be able to stop the infringement of your work. Logo words such as turmeric, whether they can have a trademark, of course not, because this is a traditional knowledge. Neem, turmeric, this cannot be part of a trademark that could belong to a particular individual. But there is something called as geographical indication, and that is where a community as a whole can actually protect a mark. For example, basmati rice, which actually grows in a particular region, and you could get a protection under that. So, well, I don't want to at this stage go into what intellectual property forms are, how do we protect them, what are the litigation costs, and everything, connected with anything that is detailed into IPR. It would not be right on my part to discuss in this 30 minutes only. In fact, 30 minutes are over. And I have not yet finished up with my presentation. So I will put a stop in replying to your questions. I will just quickly take you through the presentation in next 5-7 minutes or 10 minutes. And then we open up the floor for all the discussions. Like we said, 30 minutes for presentation and next 30 minutes for your queries. Since I've taken a few, let's reserve for the later time. Okay, so IP monetization, and there are different ways how you monetize your IP, how you can actually seek, return for the investments that you would have made, or return for the use of your intellectual property. And there are different ways, like I told you right in the beginning. Whatever you can do with your physical asset, you can do with your intellectual asset. You can license your IP. License can be exclusive, it could be non-exclusive. Depends on what kind of terms and conditions you are signing up with the licensee. You can sell or assign it also. You can sell or assign it to a company, to any other licensor, or else you can also claim your damages or profits in the court where you have ended up filing a court case against someone who was misappropriating your IP and was not paying you. So these are few ways that I have just listed, but there are several other ways that one can look at. IP as a collateral is again a very important subject because most of the startups, engineers, other creators, developers, they usually find dearth of money and they want some funds. And intellectual property actually can be utilized and kept in the bank or given to the bank as a security. Like you give your gold as security to get a loan, or your home you give it to the bank for the security purposes. Similarly, intellectual property also can be used as a collateral. Especially this is very famous in the copyright area, where you may have written a book and it is selling and you want to grow up and you want to scale it up. For that you need a money. You go to bank and say that, okay, this is the amount of royalty that I'm receiving every time, and I'll be able to pay back to the bank. And that is how you can use your intellectual property for getting some loans. Kingfisher has been one of the companies that was able to get loans by keeping trademark as trademark of Kingfisher as a collateral for getting money from the bank. Of course, unfortunately, it became a non-performing entity later, and it became very difficult for banks to recover its money. But yes, if your product is selling well, if your intellectual property, you have got complete documentation to prove that you'll be able to pay back, I think it's good way to actually receive some funds. There are different constituents of intellectual property. You have got trademark, patent, design, trade secret. Trade secret, we don't have a separate law in this country, in India, but yes, it is there in other parts of the world. Geographical indication as well is a part of intellectual property, and you can do so many things with your IP like we just discussed. The question that usually is asked by the audience is, can I also be part of this IP ecosystem? Yes, you can, because it's just a myth that maybe you need huge financial investment or you need a huge backup for you to come up with something innovative. Even if you don't have that, you have got just an innovative bent of mind, you can still go ahead and be part of this IP ecosystem. In fact, there are some very good examples, for example, Post-it. I'm sure that you must be using these Post-its in your research papers and just to earmark what is written in what page, and it is such a light glue that you can actually remove it at a later stage also. Now, this inventor, when he came up with, he actually wanted to invent the world's strongest glue, and he ended up making world's weakest glue. And he thought maybe it's an end, nobody will buy his glue, but you look at how Post-it has become so famous amongst all of us, and we all use it for everyday work. There is another example of Velcro. We see Velcro in our apparels, we see Velcro in our sandals, Velcro in our bags, and it was just a sheer observation of that inventor which led him to come up with this beautiful innovation. He was passing by a farmland and he found that आपने वो देखा होगा, there is a plant. I mean, it has a stick, it has a long, head which gets stick to your dress if you're moving along, and you have to really pick it, pull it up to remove it from, if you've been able to encounter it, I think in some jungle or safari where you go, you must have seen it. He was observing it. It just got stick to one of his dresses. He was pulling it up and he said, why don't I create a Velcro out of it? Because if something can stick so well, he actually got inspired from nature, and he created Velcro. And he's been earning a lot, and it didn't require him to do any R&D. It didn't require him to sit with a lot of books with maybe a PhD degree to come up with something so innovative like this. So I think when it comes to IP, you just have to keep your mind open that intellectual property which surrounds you all the time, you can also yourself be a creator of IP. Okay, so this is very important, how IP can shape up your career. I know there have been traditional career choices. You want to become a lawyer, doctor, engineer, manager, a teacher, and for that matter, any other traditional career choice that you make for yourself. In every such career choice, you need to have intellectual property component in your mind, in your understanding, so that you can you can be the better worker in that particular sector. Well, IP can be, as I said, it can be in your existing profession, it can be utilized, or you can build a specific career in intellectual property itself. For example, I can take my example here. IP has been my career choice, right? When I was very young, and I wanted to be a IP professional, and today, as we speak, I landed up into an IP advocacy stream where I'm able to contact or connect with different stakeholders, including government, companies, and we work on the policy reshaping. There could be also career choice in teaching. For example, what I'm doing today with you, interacting with you in the academic area, and there could be several other things. Let me just take you through some of those. So there are three general options. Either you are a science graduate, or you are from commerce, or you are from humanities or arts. In each of these sections, for example, if you pick up science, and if you belong to a sector or an area of engineering, or within science you belong to medicine side, you're a doctor, or from a dentist as a profession, or there could be several others, or it could be commerce, whether you are an accountant, company secretary, you are in the economic side, or you are in arts, where you are, Arnab Goswami and Barkha Dutt. They're all from the art side, and also from the legal background for sure. But how much content they've been able to create by taking interviews of different people, they need to have their own intellectual property. Like when Arnab wanted to come up with his own TV channel, it was all the dispute of that word, that nation wants to know. Now, whether nation wants to know as a word belongs to a TV channel where he was an employee earlier, and he made that TV channel so famous by the use of this word, where he wanted to now open up his own company and he wanted to use the same name. So it's all about it's all a game of intellectual property. So everywhere it will not, you cannot escape from this such an interesting subject matter. In fact, there could be several career choices. If you are an engineer, you need to be aware of patents as well as trademark, design, and copyright. If you really belong only to an area of, from the background of commerce, you need to know more about trademark and copyright. If you just belong from the area of art, copyright and geographical indication, trademark becomes all the more an important area for you to know about. So within each sector that you may belong to, I don't know if I'm talking to lawyers at this stage, at this minute or not, because I think there were some law students who were expected to be part of this training as well. But if you're a lawyer, you can actually pick and choose the subject of IP in the litigation side. You can actually go to the court, fight out a case for a company that may be either facing misappropriation of IP or the non-performance of contract. If you are from an engineering background, you can as well pick up a career choice of being a patent prosecutionist. You can pick up a choice of being a patent agent, an Indian patent agent, where you can file and prosecute patent application on behalf of your employer or behalf of your client. One can become a teacher or a faculty, like I just mentioned, or in the IP advocacy area. In fact, one of the very upcoming and a very, very important career choice that is now coming up is the IP valuators. Because today, if you go to bank and bank से आप मांगते हो कि मुझे इतना पैसा चाहिए, you need to keep your IP as a collateral and you need to prove what is the value of your IP. Similarly, if somebody was misusing your IP and you go to the court and you ask for damages and profits, you need to first know what the value of your IP is. Today, at least in India, there is a dearth of good IP valuators, and by learning about this IP, I think you can make a career choice in that, and that's something which is most now needed. One can be an IP advisor. I mean, this slide, if I stay here, I can maybe spend another 2 hours, but let's go ahead because I have got few other. Okay, so let's now come straight away to intellectual property talent search examination, because of which we are all able to connect with each other, because of which I'm able to convey you about what this project, what this initiative is all about. This initiative is actually a combination or a collaboration of efforts of many, many people, many stakeholders, and you know, just like you heard Gaurav, opening up this one, he is an important part of this important initiative. Similarly, just like Gaurav, it's me who is part of this important initiative as individuals, and there are so many others who are putting their time and energy in this noble cause of letting the community, the young generation, or different levels in the society become aware of this important subject matter. If you can see SOCHAM, Ericsson, Ministry of MSME, Ministry of Science and Technology, these are all important supporting partners who all have, given their inputs to bring this IPTSE to a level where we are able to conduct an annual examination. There are continuous such webinars like we are discussing today that happens over a period of years. Then once a year, you take this exam. And there are so many other universities, including AICT, which actually regulates the entire education institution here, has been important part and parcel of this initiative, and so many others that you can read at your convenience at a later stage. There are important timelines I thought I must tell you, that the registrations are up till 31st of January, and I really encourage you to be part of this. We expect to introduce examination for this session in the month of March, first 2 weeks, first week of March and the second week of March, where the exam will be conducted in 2 batches. And then there will be a award ceremony. For at least past 2 years, we've been blessed to receive, presence of honorable ministers who have been giving awards to different schools, colleges. There is an award in the form of trophy, in the form of some small other monetary reward. So it's, I truly feel as an Indian citizen that intellectual property is important, and through this platform, you can actually become more learned, because the kind of intellectual questions that I'm able to see in the chat window from all of you, most of these are attempted to be answered by us in the form of course booklets, in the form of other important web links that we provide, and in the form of webinars. There is also a study material which captures patent, the information about patent, trademark, design, all these 7, in a very story format. It's in the form of almost, you can say it's an interaction between a child and a mother, a child, one student with another student, and there are certain examples that we've put in so that you're able to correlate it well. This exam is actually a competitive exam, I would say, because you really compete with each other because you want to be a winner, and therefore, school students compete with each other, college students. Therefore, we don't name it because name is actually IPTSE, but for the general ease of, connecting, we actually call it as IP Olympiad, for the reason that you do your self-study, you take these webinars, you connect with us on certain course material, and finally you take the exam and you get a certificate. Mode of examination is all online. You don't have to go anywhere, but you can sit at home. It's a limited time. You cannot switch multiple times your windows because we've tried to make sure that students really work hard, learn about this, and don't really just plagiarize, where you are asking your other friend to tell you the answer. We've tried our level best to minimize all of those loopholes or gap areas. And so examination is really important in that sense, where you study very well. And there are some details about the prize, and you can actually go to IPTSE website at a later time and you can see who earns what, who wins what, and at what level. Okay, so this is the end of my presentation. It's 11:47. We have, I don't know why this S appears. Maybe I wanted to write something and I forgot to write. There are, okay, yes, I wanted to write one more email address actually. But for now, inquiry@IPTSE is the mail ID where you can inquire more about this program, this initiative, this examination. And we all will be more than happy to support you and give you the replies. So Gaurav, here I end. If there is somebody you want someone to speak at this stage, I'm more than happy to take it. And if you direct me to take the questions, I can do that well. That way also.
Thank you, ma'am. Thank you for your presentation. Now we go ahead and take some time for questions. And I request all the attendees to kindly go ahead with your questions regarding the IPTSE or any part of the presentation you would like to get cleared. And ma'am, we have questions in the chat box. I'm posting it to you.
I just cannot move. Okay, now. So Nihar Bali is writing, it helps to know the IP very well and it is very beneficial. Yes, indeed. And then Suman Kumari is asking what would be the benefit of this exam. Suman, this is the question which we usually hear from so many of prospective candidates. The benefit of the exam, one key benefit of the exam, and I think that should be the only your mindset, is that you learn about the subject matter. You become a good individual as you grow up in your career. You become a literate IP Indian citizen, and you can do so much for your society back if you have a reasonable amount of understanding about this IP as a subject. And therefore, I think with that mindset, the benefit of this exam is immense. But since you also get a certificate at a later stage when you are in some career making, when you want to, put up your resume somewhere, you can actually say that you have passed out this examination. And therefore, it's also an image building process, not only for anybody who is taking up the exam, but also for us, that we make our level best to help you learn about this exam. You can also take certain internships because the winners, at least if I'm not wrong, IPTSE offers internship opportunities. And if you really find the subject very well interesting, you can as well build a career in this stream, like we discussed very briefly in the previous section. Okay, Likhit is writing, it is mentioned on WIPO website the validity of copyright is 70 years from the date of death, whereas IPTSE's PPT, it is 60 years from the date of death. See, WIPO and Indian Copyright Act, you cannot compare it as such, because Indian, you have to, when you are reading Indian Copyright Act, you have to look at the statute book here. What is the term written? And it's 60 years from the date of death. So until the time author is live and plus 60 years. So if you're looking at the US Copyright Act, then you look at the patent copyright statute book of that country. And therefore you might find certain variations in the term of protection in different countries. And therefore, I truly appreciate that why your concern has been such. So look at the statute books of that particular country where you want to learn more about that. How Sandesh is writing, how to make a career in IP evaluation. Are there any exams? Well, no, not yet at the moment, because at least in India, there is no specific course by any university or institution that gives you this particular modules and takes you through an exam and gives you a certificate. But yes, there are certain programs which are available by certain private education institutions, and that you can actually search in the website and look for it. But there is nothing so specific that I can actually mention to you, which is professional in the sense that from universities and education institutes. I haven't seen it yet. There are Likit writes again, and he says, if I take a screenshot of any image from Google without permission of an editor, will it be an infringement? Well, it depends. What are you using the screenshot for? Is it for commercial purposes? Is it for critics purposes? Is it for education purposes? What it is for? If it is just for critics, under Section 52, there are certain exemptions which are given where you can use someone's work, the copyright work, without really having to worry about the permissions and royalty, because you're using the work for a very specific purpose, which is to maybe teach someone. Like, if I have been presenting this to you today for purely academic purposes, just to help you learn, even I took certain screenshots, but I've given attribution. So today's workshop is not a paid workshop. It's absolutely free workshop. No one is earning out of it. So therefore, it completely depends on what are you using that particular IP for us to then decide whether it will lead to an infringement or not. But just to give you an instance of where you are sitting in a movie hall, and there is a movie being played, and you are clicking photographs or maybe making a small video out of that movie and you put it on the web, it is an infringement. Because later on what happens is that, people stitch these small parts of the movie and put it on the web, and that eats onto the revenue earning by the publisher or by the producer, because nobody would then end up going to the cinema halls and watch a movie. They'll be happy downloading it free of cost from the website. So it maybe you, when you recorded the movie, you didn't want to commercialize it, but then if you have ended up putting it on a website and there are so many clicks and it is actually leading to loss of profit to the producer, then of course one may have to face the litigation. Likit is again writing, if a novel crop grown in a land, so this GI or plant protection. Well, GI is for a particular name like Basmati rice, Kolhapuri chappal, or Agra ke pethe, or Agra ka wo kya hota hai, Anguri petha. So that's for a name. But if you want to protect that crop as such, the genetic code, the genes of it, and the variety, then it is plant protection. I hope this helps you. Is there any organization for patent for the whole world? No. There is no worldwide patent. As I already responded to one of the queries, patent is territorial. You have to look for a protection. You have to seek a protection in each country where you want to have an IP. There is no global patent. Ayushi Rao is writing, ma'am, if you have established a brand in India and want to go global, but in another country, same name is registered, what will then happen? Of course, if that registration is already done in the other country and you want to go there, you cannot because you have to see who was the first one to register it. And if you are an established brand in India, I really doubt why wouldn't that owner of the trademark would have not sued you yet here in India. Because if it is that well known, which means it becomes well known when people start to recognize it. Well, again, it depends on what case are you really talking about. Is it a case where the registration of the trademark in that country happened later and your prior use of trademark was missed out by the trademark examiner over there? Or were you able to register it as well in Indian Trademark Office? And whether you took advantage of the Madrid Protocol. So it completely depends. I mean, there could be a lot of questions that as a lawyer or as an advisor one might have to ask you to really give you a final answer. But in principle, if there is someone else who is the owner of the mark, you must seek prior permission. And in fact, if that mark you would have wanted to protect in your prior art search, that would have anyway come up that there is someone else who is owning it. Gaurav is writing, what about a particular color or a shade under which IPR it is registered? Okay, so this is from Astha Deshpande. So color or a shade per se cannot be protected, but if there is a scheme of color and a shade, there is a particular format in which you have put it, may or may not be along with, let's say, some words. For example, if I'm not wrong about the scheme of red color which is used by Airtel, it's half up there and half there. So it's a particular scheme of color and shade, then yes, you can use it as a trademark, as a logo as well, under which you want to sell your services or products. It could also be a part of copyright if you want to put that particular scheme of color and shades onto certain apparel, where the number of apparels that you manufacture are less than 50. Otherwise, it becomes a part of a design if it is actually embodied into a physical form. So, interesting questions. We have just 2 minutes left. Okay, so I'm so sorry. I was all the time saying Gaurav. Gaurav is is a presenter, and I missed out the names of people who are actually posting this. So there is a question from Hyderabad. I'm extremely sorry. I was taking wrong name and assigning that name to a question which was actually asked by you. I really apologize, but there is a question from Dr. Zahir from Hyderabad where he's asking, shall we register first an idea or try to develop it first and go for IP registration? Well, which IP are you talking about? Are you talking about a logo, a mark, or you are talking about an invention, a technology, or are you talking about a design? What IP are you talking about? If, let's say, you are talking about an invention, a technology, then you cannot just go and file a patent for it unless you have something to show to the patent office. The research that you may have done, the best mode enablement to reduce that invention to practice. You have to have a good amount of data for you to go and protect your IP. When it comes to trademark, you can actually go and protect the logo even before you have launched your product. And therefore, it completely depends, if your idea you are developing, which is completely a technological side of it, you're developing a product, you're developing some software within it, then certainly you need to have certain data for you to protect it. Otherwise, it becomes such a chaos. Everybody will just have an idea, have an idea and protect. There are, if you read the patent statute book, there are certain criteria that needs to be met. The formalities, for example, under section 10, you need to show how you practice your invention. How do you reduce it to practice? What are the prior art that you've gone through? What is the solution that is being met by your invention? What was the problem in the art that you wanted to solve? So all of that you need to have answers. You should have done something before you file at least patent. YouTube content, there is a question from Ayushi Rao. Of course, the entire YouTube content that you create belongs to you, and you have a complete right over it. In fact, when you create a YouTube content, you need to be also very sure that you do not infringe on the YouTube content or any other IP content of someone else. Like I've seen a lot of bloggers, or YouTubers who come up with some sort of video, and in video they are using a lot of images famous images or the content that actually belong to someone, and they have been actually sued to put the entire content down. If I were to give you my live example of YouTube, one of my book, which was scanned by someone and was entirely put on its YouTube. It was actually giving all pages of my book from 1 to 400 in different sections, and I could scroll through, download, do whatever, and I had to file an immediate notice to YouTube to put that content down because it belonged to me. And such a great thing that YouTube was able to put the content down within 24 hours. So either you create a content, or when you're uploading some content on YouTube, you need to be very sure whether it really is all yours or it also some content belongs to someone else, and if at all you have taken some due permission, and if it is an orphan work, you could not get a permission, you don't know the creator, but at least you have given the source from where you have taken, at least safeguard yourself. So that's in brief about it. Nimish Garg is asking, this is the last question we take because we have already, it's already 12:02. Ma'am, if we don't have a patent, if we don't patent our IP, maybe our IP can be used by someone in profound way that we might never have thought of before. Of course, yes, there could be different use of your intellectual property that you may have created, but there is always a great opportunity for you to cross-license, because maybe you had an IP for a particular use and there was some other IP that the other person was able to secure, which was an improvement over your intellectual property. Then of course you can talk to a person, and if it all belongs to you, it has been adequately protected, then that person cannot use it unless he pays you or takes your due permission and signs up relevant terms and conditions. So I think with this I will stop. I hope you like this session. If you have, put it on the chat window. Do also put it on the chat window if you did not. And if there are any areas of improvement you would like us to bring in next session, I think those are very important. Over to you, Gaurav.
Okay, thank you, ma'am. It was great to having you here. As we bring this interactive session to an end, I would like to thank everyone for joining us, and I hope we were able to clear your doubts and queries regarding the IPR and the IPTSE examination. And we welcome all the attendees and the faculties to please reach out to us in the mail ID given at the chat box, and we will be happy to answer all the queries. And we also expect everyone to be part of this program, and we are sure that we will be coming up with another part of this interactive session at some later date. We will be informing. And to all of the students, thank you very much, and thank you, ma'am.
Thank you,
Professor Chan, we end this session right now.
Thank you.
Okay, ma'am.